The Environmental Protection Act of 1994 requires that the seller makes a specific disclosure before entering into an agreement with you if any of the following are applicable to the land, including the common property if it is in a community title scheme. A. The land is listed on the Contaminated Land Register or Environmental Management Register. B. The land is the subject of a notice or evaluation under the Act, generally about possible contamination or notifiable activities such as underground fuel storage. Or C. A magistrate has issued an order under the Act for an authorised person to enter the land to conduct an investigation or to carry out work. If any of these apply and the seller does not give disclosure before you enter the contract, then you may terminate the contract before the earlier of settlement or possession. If the seller has not complied with these disclosure obligations, the seller may give disclosure after the contract has been entered into, but in that case you will be given a period of 21 business days after the seller's disclosure to terminate the contract. If you do not terminate in that time, you will lose the right of termination. Given the limited time period available for termination, it is important that you contact us promptly if you receive a notice from the seller to remedy a failure to comply with its disclosure obligations. If you terminate the contract because of the seller's failure to make relevant disclosure, all money paid by you under the contract must be refunded. The searches we undertake only identify land on the Contaminated Land Register or the Environmental Management Register, but not notices and orders. If you think the land, including the common property if it is in a community title scheme, may be contaminated, consider that prior or current use of the land might contribute to any contamination issues, or think that any notices or orders may affect the land, please contact us as soon as possible so that we can take the steps necessary to address the issue.